Hello guys, and welcome to another episode of my lecture. I've spoken in my previous lecture about the rule 1 of the nature of a confessional statement. In this particular lecture, I'll be talking about the rule 2 of the nature of a confessional statement, and let us go straight to my notes. Now, rule 2 states that if a court of law rejects a confessional statement for being tendered in evidence or expunges it in its judgment, it can still validly rely on the oral version of the confessional statement made by the defendant to any of the prosecution witnesses. Now, this was made clear in the case of AROGUNDADE versus the state by ONNOGHEN, Justice of the Supreme Court of Nigeria. Justice ONNOGHEN said, "The learned counsel for the appellant is under the erroneous impression that the original written confession of the appellant, having been expunged from the record on whatever ground, the oral confession made by the appellant to PW5, that's prosecution witness 5, is thereby rendered inadmissible without the appellant raising a separate objection to its admissibility. A confession may be oral or in writing. In the instant case, they are both. Does the expunging," now this is where the very important question comes in, "does the expunging of the written confession make inadmissible the oral version of the confession of the appellant to PW5, who was not the person before the written confession was made?" And then Justice ONNOGHEN answered, "I think not." That is a very, very important and powerful, judgment by Justice ONNOGHEN. Now, I already explained in my last, lecture where I was talking about rule 1, where I told you that you can have both oral and written confession in a case. In the case of AROGUNDADE versus the state, we had the two of them in a particular case. The both of them were admitted, both the oral and the written. But in the judgment of that particular court, he expunged, that's the judge expunged the written version, but there was still the oral version, and it was based on that oral version that the accused was convicted. Now, when they appealed on the basis of expunging the written version and still upholding the oral version of the confession. That when you've expunged the written version, it means that you are admitting, that the judge is admitting that there was no confessional statement made, or even if there was, then those confessional statements do not meet the requirement of the law. So why then will you expunge just the written version and then not expunge the oral version? Justice ONNOGHEN said that where an accused makes a written confessional statement, also makes an oral confessional statement, the mere fact that one has been expunged does not mean the other would be expunged. It means that the counsel for the accused would also have to raise an objection to both the written and the oral. You don't raise objection to just the written and then you leave the oral alone. You have to raise objection for both of them, because when one is expunged, the other will still stand. Do you understand that? So the same thing that you would do for a written confession is the same thing that you must do for an oral confession. The same way you are going to have a trial within trial for a written confession, you must have a trial within trial for an oral confession. I'm going to still explain the whole details of a trial within trial in next lecture, but in this particular lecture, rule 2, you should know the mere fact that there is a written confession and there is an oral confession does not mean that the moment you expunge the written confession, you should expunge the oral confession. And there's also one thing that Justice ONNOGHEN said. He said, especially the fact that the oral confession was not made to the person that the written confession was made to. So let us say there were two policemen. One policeman got the oral confession, one policeman got the written confession. Then that would mean that where the written confession has been expunged, the other confession made by another policeman would not be expunged. But if it is the same person, because the written confession has been expunged, especially when it wasn't gotten without threats, that means that they threatened the accused, or they oppressed the accused, or they did some form of duress on the accused. Then, because it was the same person that collected the written confession and it's the same person that collected the oral confession, then it is possible that an objection on the written confession will expunge, if the written confession is expunged, will also expunge the oral confession. But if it's not the same person that collected the oral confession and the written confession, then it means that you must raise two different objections. In fact, if it's the same person, if you can show two different timelines, that when the oral confession was given, it wasn't given on those circumstances, but when the written confession was given, the written confession was given under circumstances that can warrant it being expunged from evidence, then you can still have the oral confession, even when made to the same person, still stand in evidence. So that's the reason, as a lawyer, you must scrutinize the whole statement of, both the policemen and other witnesses to be sure how and when to help your client, how and when to object on certain important key issues. That is why the law of evidence is one of the most important. While contract is important, criminal law is important, land law is important, and almost every other thing is important, law of evidence is even more important, because without it, you are going to miss certain key things that you should have objected to, or certain key things that you should have noted. And that's why I end my second lecture on the nature of confessional statement. That's rule 2. In my next lecture, I'll be talking about rule 3 on the nature of confessional statement. I'll see you in my next lecture.